The House Municipal Finance and Local Government Committee will come to order. Madam Clerk, would you please take the attendance?
Chair Fitzgerald.
Here.
Representative Burns.
Here.
Shannon.
Present.
Green. Rogers.
Here.
Hill.
Here.
Hoskins.
Here.
Pies.
Present.
Zorn.
Here.
Paquette.
Here.
Bizat.
Here.
McGoal.
Here.
Preston.
Yep.
Mr. Chair, you have 12 members. You have a quorum.
Thank you very much, Madam Clerk. With that, I need a motion from a member to adopt and approve the minutes from the previous meeting, April 17th. That motion is made by Representative Pies. Seeing no objection, the minutes will stand approved. With that, we're going to continue testimony today on House Bills 5437 through 5446, otherwise known as the Short-Term Rental Act. For those wishing to speak to the bills and we didn't get to you last week, I apologize. We moved committee along in the best manner possible to allow for some time for questions and did need to make some amendments to our schedule accordingly. So today we are also on a little bit of a time crunch, and so please do your best to limit comments to 4 minutes each. We will be, again, like last week, giving you a 45-second warning by holding up the green book here. Served us pretty well last week. We'll do the same. So for those who are testifying in person or by Zoom, look for the green book here, and that will note that you have 45 seconds left in your testimony. So with that, I'm going to bring or call forward here Dina Bosworth from Michigan Association of Counties, wishing to speak and has concerns on the bill. So Ms. Bosworth, when you are ready, you may have the floor.
Thank you, Mr. Chair and members of the committee, for allowing me to testify on this important 10-bill package. Now, I did put concern on my card, but overall, you'll see that we're very much supportive of the overall concept. I would also like to thank Representative Andrews for taking on this issue and for his willingness to consider amendments to this legislation that will recognize counties as a municipality with responsibilities and resources related to short-term rentals. Counties were not originally included in this legislation, and in our opinion, they should be. We have 20 counties across the state that have a significant amount of responsibility in planning and zoning. We also have hundreds of local units of government that solely rely on counties for public safety and emergency response. And so that's why, one of the reasons we believe counties actually should be included in this legislation. This package has two overarching themes, right? First, to allow for the registration and regulation of the short-term rental industry and to provide much-needed revenue to local governments to provide for the facilities, the infrastructure, and services needed to maintain the desirable locations to live, work, and play in Michigan. For the most part, it appears that all interest groups support a statewide registry. Local governments agree on the need for appropriate zoning of these businesses and the common sense safety and communication requirements set forth in the main bill. What is not in agreement is also very clear. Local government access to revenue to support the cost of tourism. As you may recall, Mr. Chair, during the consideration of your previous bill, House Bill 5048, which increased the accommodations tax for certain counties in the state, I testified to the fact that all counties across the state would like the opportunity to institute some sort of accommodations tax to assist in economic development in their counties, instead of choosing just which particular counties have access to funds for improvements to their area and economic development. But we also need to recognize that they need resources to support the delivery of services to the residents and tourists within their county borders. That request was met with significant opposition from interest groups that collect accommodation taxes for the promotion of tourism in their area. This opposition is perplexing to counties. As was previously stated in last week's testimony, there are significant costs and wear and tear on government resources and infrastructure as a result of tourism. It is counterintuitive to promote an area and then deny that area the resources necessary to continue to make it safe and attractive to tourists. Let me be clear, MAC supports tourism and the promotion of all Michigan has to offer. However, counties and municipalities across the state are struggling with having enough resources to invest in our facilities, infrastructure, and emergency response personnel. We want our residents to enjoy the resources and services that they pay for, and we want them to have access to public safety and emergency response personnel, even when there is a large influx of tourists to the area. To wrap this up, MAC would like to see this legislation develop in a way that recognizes that all counties across the state would like to have access to funds for economic development, that counties across the state play a critical role in the planning and zoning of communities, counties across the state have significant infrastructure responsibilities, and counties across the state play a critical role in providing services to residents and tourists alike. All of those responsibilities require resources, which the tourism industry has been very reluctant to share. And with that, I would be happy to take any questions.
We're going to save questions for the end or for subsequent hearings as well. So, Ms. Bosworth, we appreciate your testimony here today. We do have, I'm going to count here, 5 others who are prepared to testify here today. So we're going to move on to a Zoom testimony from Mike Bozick from Granicus, here wishing to speak in support of the bill. Mr. Bozick, the floor is yours. And again, we'll hold up a folder here with 45 seconds remaining in your 4 minutes. You may begin when you're ready.
Great. Thank you so much for having me. Yeah, I work with a company called Granicus. Not only have I worked in this industry for many years, but I grew up in a resort community in Telluride, Colorado. It's only a mile long, with less than 2,000 full-time residents that are getting driven out of the community, while tourism has always been and will always be a huge part of the company or the community's identity. So, my hometown's faced and is still facing many of the same issues presented here today in the opening statements from the last session as well. So those really resonated with me on a deep level. And I also happen to work in this space and have for many years. So when it comes to Granicus, we work with over 5,500 government entities in a number of different ways, 30 Michigan communities specific to short-term rental identification compliance. In fact, we're already working with the state of Michigan as well in a couple of different capacities. We created and pioneered this industry of short-term rental identification compliance software in 2015, and we specialize in that. We do everything from identification and notification, registration, fielding complaints, tax remittance, flagging when anyone expected to be underreporting on taxes, identifying the amount of tax owed, legislation relating to short-term rentals, a lot of different things. Now, I'm not necessarily here to take a stance on the specifics of the bill, but I do agree that a tax can be a revenue generator that can make a significant positive impact on a number of different initiatives throughout the state for its residents and its constituents. And I think it should be simple. I think the idea of a straightforward tax makes a lot of sense. And I also agree that these communities throughout the state also being able to enforce individually is a great thing too. So the great thing about the bill, and I think it's necessary. The great thing about it is that the state already utilizes 2 solutions that could be the solutions to register short-term rentals. So this is not something that would have to be stood up from scratch. One of those sits within Laura already, is used by Laura. Another is actually a Granicus solution. The state already utilizes a citizen engagement communication tool as well that could be used to get that outreach and talk to subscribers, communicate with subscribers through text, through email, through social media. We already do that for the state. So I do see Michigan being set up for success more than any other state. But I will say that a tax, I think, is necessary. In Alabama, there's over $26 million that's out there that can contribute to a number of initiatives. In Utah, over 55 million. We've identified that there are over, I know a number was given around 9,000 short-term rentals throughout the state. Our data is a lot more granular. We're identifying just south of 33,000 short-term rentals throughout the state. And we see with the data, with the nightly rates, occupancy, that 6% excise tax could generate about 67 million a year if this bill were passed. So it is something that I think is necessary, especially to have a registration. Even though there's a registration system where people can register, the identification still needs to be done. And to do that, a bill like this would have to be necessary. So thank you.
Thank you very much, Mr. Bozick. I appreciate. Is it Bozick or Bozich?
Half my family says Bozich, but the correct size, it's Bozick.
I like it. You can't be wrong. I appreciate that.
Yeah.
Thank you very much, Mr. Bozick. I appreciate your testimony here today. With that, we'll move on to another Zoom testimony. Wishing to speak in support of the bill, Gordon Gallagher from Spring Lake Township. Mr. Gallagher, you have 4 minutes, and the floor is yours.
Perfect. Thank you. Are you able to hear me?
Yes, sir, we do.
Great. My name is Gordon Gallagher. I'm the township manager for Spring Lake Township. Spring Lake Township is an attractive community along the shores of Lake Michigan. In Ottawa County, we have a population of about 15,000 people. In 2017, we had over 6 months of community discussions on regulating short-term rentals, including meetings that had to be held in our middle school auditorium. We put in place regulations on short-term rentals, which balanced retaining neighborhood character with the ability for individuals to rent both short-term and long-term. And we included an exception to regulation for under 14 days of rental per year. We defended our ordinance all of the way to the Michigan Supreme Court, where we prevailed. And we believe that we prevailed because our ordinance balanced the community's interest with private property rights. In other words, we passed an ordinance that was right for our community. The things that are in HB 5438, such as requiring smoke detectors, are very similar to regulations that we included in our local ordinance. In addition, we require compliance with the 2015 International Property Maintenance Code, which serves most Michigan communities as their property maintenance code, and we require adequate off-street parking. The bill as proposed is an excellent example of state and local government working together to find mutually beneficial solutions. This bill as presented provides for reasonable local regulation. So thank you for giving Spring Lake Township an opportunity to comment on and also to offer support for House Bill 5438.
Thank you very much. We appreciate your testimony. With that, we're going to move on to Mr. Mitchell Treadwell, Commissioner from Traverse City, Michigan, wishing to speak in support of the bill. Commissioner Treadwell, you may begin when you are ready.
Hi, can you hear me?
Yes, we can. Thank you.
Yes, I'm Mitchell Treadwell, City and Planning Commissioner for City of Traverse City. As a Lake Michigan community and a popular tourist destination, short-term rentals have had a significant impact on our already acute housing shortage in the region. But I think that Traverse City, as a local community, spent a good deal of time and effort in drafting regulations that work for our community with regard to short-term rentals. Are they perfect? No. In fact, our Planning Commission has created an ad hoc to refine our regulations further. But I think that they were a good step in recognizing the need for a community like Traverse City to have the tools to say what the proper number, distribution, and location of short-term rentals are in our community. With the demand from tourists and other visitors to the area, short-term rentals can represent a displacement of permanent residents that would otherwise be occupying the same housing units. In adjacent Leelanau County, my own sister had been living in a duplex that got converted to a short-term rental, and through that displacement, she is now living with her boyfriend in an RV on our family's agricultural land. That is not a situation that we want for people that live and work in our community. These bills, I feel, take a good step in having some uniform statewide regulations for short-term rentals that can avoid some of the situations where you have a zip code, say 49684, Traverse City, that spans both inside and outside of the city limits and has a more uniform policy statewide while still allowing a lot of local flexibility for each community to decide what the right number and zoning requirements are for short-term rentals in their community. Furthermore, seasonal residents, be they short-term rental people or people staying in a hotel, have significant impacts on infrastructure that these bills allow a funding source that can help ameliorate. We have increased demand on our road system, increased demand on our water and sewer system, and with tourists, that demand is much more seasonal, much more concentrated on weekends and in the summer. We don't have a current revenue source that can specifically tap into that seasonal population. And this assessment on short-term rentals through the state would allow us that tool. So we look forward to these bills moving forward, and we are strongly in support. Thank you.
Thank you, Commissioner Treadwell. We appreciate your testimony. With that, we have two remaining testifiers here today. One again by Zoom. That's Laura Chadwick from the Travel Technology Association, wishing to speak in opposition to the bill. Ms. Chadwick, you are free to begin your testimony when you are all set.
Thank you. Chairman Fitzgerald, Minority Vice Chair Zorn, and members of the Local Government and Municipal Finance Committee, thank you for the opportunity to speak with you today. My name is Laura Chadwick, and I am President of and CEO of the Travel Technology Association. My organization represents the leading innovators in travel technology, including online travel agencies, short-term rental platforms, global distribution systems, meta-search companies, and travel management companies. Our members' vital role in the travel and tourism industry empowers consumers, creates a fair and competitive marketplace, fosters accountability, and promotes positive customer experiences. Michigan has and continues to derive a very real economic benefit from the presence of short-term rentals and the travelers who occupy them. Unfortunately, some of the provisions of HB 5438 raise serious legal and practical concerns. For example, various provisions of this legislation violate the Federal Communications Decency Act 47 USC at 230, also known as the CDA, because they would impose liability on short-term rental platforms for publishing third-party content. Specifically, HB 5438 would prohibit platforms from facilitating a booking transaction for a listing that is not currently and validly registered with the State Department of Licensing and Regulatory Affairs. However, Section 230 of the CDA prohibits state and local governments from holding platforms responsible for the acts of others. The CDA establishes broad federal immunity to any cause of action that would make service providers liable for information originating with a third-party user of the service. In providing, quote, a broad grant of web host immunity, unquote, the CDA, quote, gives effect to Congress's stated goals of promoting the continued development of the internet and preserving its vibrant and competitive free market. In particular, the CDA bars plaintiffs from holding websites legally responsible for information that third parties created and developed. Any state or local bill that is inconsistent with these holdings is preempted by the CDA. Additionally, the data sharing requirements of HB 5438 may violate the Fourth Amendment to the Constitution because they would compel disclosure of business records and personally identifiable information to a government entity without valid legal process. The Fourth Amendment and state corollaries protect individuals and business information and limit disclosure to governmental entities. Federal courts have stopped enforcements of laws that, like HB 5438, required short-term rental platforms to provide reports of business and user information to government officials without any legal process. Portland, New York City, and Boston enacted laws requiring short-term rental platforms to submit monthly reports that included owner information, property address, and transactional information. 3 federal courts enjoined enforcement of these laws, ruling that requiring hosting platforms to disclose their business records without any legal process violated the Fourth Amendment and/or were preempted by the Federal Stored Communications Act. When platforms partner with local governments, it is imperative that they adhere to privacy and constitutional safeguards in compliance with applicable federal and state laws. Finally, HB 5438 would unfairly tax short-term rentals at a higher rate than hotels by imposing a 6% tax that would apply only to short-term rentals. This significant surcharge is discriminatory and would impede competition by disadvantaging short-term rentals vis-a-vis conventional lodging, giving an unfair advantage to national hotel chains and fewer lodging options for travelers to and from Michigan. In
Ms.
light of these issues,
Ms.
I
Chadwick,
strongly
Ms. Chadwick, I apologize. That is the end of your 4 minutes allowed here today. So we are going to have to move on to our next testifier. We appreciate your testimony. You did submit written testimony, which will be added to the committee record. And so any final thoughts will be provided in written form to the committee and again to the committee record as well. So with that, we're going to move on. We did have one person arrive here today wishing to testify in person. That is Nicole Zagman, wishing to speak in opposition to the bill from the Kent County Farm Bureau. Ms. Zagman, you can begin when you are ready. Thank you for joining us today. And if you can just hit the red button at the end of the stalk there, you'll be set to go.
That makes things
There
a
you
little
go.
bit better. Ladies and gentlemen of the committee, thank you for your time and consideration. My name is Nicole Zagman. I am a short-term rental owner and operator, and I run a farm and agritourism operation in Byron Center, Michigan called Parkside Farm. I started hosting farm stays in 2022, and I offer a unique short-term rental experience for families year-round at our 100-plus-year-old farmhouse. I'm a member of the Kent County Farm Bureau Board, and I also serve as the Kent County Young Farmer Co-Chair. Kent County Farm Bureau recently held a legislative breakfast in Grand Rapids, which was well attended and a time of productive conversation. It was at this breakfast that I had the opportunity to connect with this committee's chair, Representative Fitzgerald. At the legislative breakfast, I introduced a question regarding support of a statewide agritourism bill, and in connection spoke with those in attendance about the importance of farm stays and short-term rentals as a valuable diversification option for Michigan farms. I was able to bring up Bill 5438 in the midst of these conversations as well. I hope to share an alternative perspective in regards to Bill 5438 and short-term rentals that are located on agriculturally zoned lands used for farm stays. With the agriculture industry facing numerous challenges across the state and increasing labor and production costs, farmers are looking for ways and new opportunities to supplement income through agritourism. I would urge this committee to consider the unnecessary burdens that Bill 5438 would impose on not only short-term rentals and hosts and owners in high residential and tourist-driven areas, but those of us who are in rural, agricultural-focused communities and towns who are utilizing short-term rentals as a necessary means of agriculture and farming diversification. After being briefed on Michigan Short-Term Rental Association or MISTRA's recent testimony, I too would not support the bill in its present state. I would be in favor of no additional taxes for local hosts and limited state regulations. I'm happy to report that after months of working with my local township of Byron Center, I'm happy to share as of this past Monday, we have a new short-term rental ordinance that was passed by our township board. In 2024, short-term rentals in Byron Center are already registered at the township level. We receive inspections and we pay for permits. We are already currently paying applicable 6% occupancy and use tax and 5% county excise tax. We are facing booking challenges in an ever-evolving and changing economy, and we are continually adapting to increased expenses such as energy, insurance, and permitting costs. I respectfully request amendments be made to the proposed bill by eliminating additional taxes and regulatory influence at the state level. Making such amendments would allow hosts to make a living doing something they love and provide a valuable experience to their local communities. Thank you.
Ms. Zagaman, thank you so much for your testimony today, and thank you for joining us here in the policy process as well. It was good to see you last week at that event, and so thank you for traveling to Lansing to engage in this process. With that, that concludes testimony for today. We do have questions from committee members, and I do know that we have one for the sponsor if you'd like to make your way forward, Representative Andrews. And we have some, I believe, lingering from last week. So I am going to start with that member who had a question last week, and that is Representative Bagol.
Thank you, Mr. Chair. And thank you, Representative, for taking on this important issue. I think it does tackle a lot of problems that are out there, but I think it does raise a lot of questions also. One particular to me is the whether there's enough distinction between, say, the All-American family who has a second home up north, likes to go up there and enjoy that with the family for vacation, but yet if they exceed less than 4%, maybe renting it out, maybe don't go up there in the wintertime, they rent it out to some snowmobilers or something like that just to try to help make the payment. If they rent it out more than, or it's less than 4%, they're in the same boat as somebody who goes in, buys a home and rents it out 100% of the time for just profit. Is that correct? In that there is no really much of a distinction?
Basically, the 14-day line is where the distinction is. And I would note that right now, if they exceeded 14 days of renting their cabin, they would fall under the IRS's provision where they would start qualifying as a business and not a personal use. So I agree that there is a difference between a person renting out their cabin once in a while and, somebody who's running a commercial operation. But we were trying to keep the distinction consistent with federal law so that we weren't creating a, kind of two different system thing that for a family like that would actually probably be more of a burden. They're probably aware of the IRS provision if they're exceeding 14 days. And so we wanted to make sure that we just sort of aligned with what they're used to.
Okay, so that's what where the 14 days comes in?
Yes.
Okay. Yeah, I can't say I necessarily agree with that because I know a lot of people that do that, and I think it's really going to limit them on whether they can own those cabins.
I think, we'd be open to some thoughts on that because I think we all agree that there is a difference and a distinction there. It's just been difficult to figure out a way to do it that doesn't then open up the activity in places like, where I live, right? Where they tried, for instance, to say, okay, anything less than X number of days, doesn't count as a short-term rental. And then what immediately happened is they would say, okay, well, we're renting this out to you for 30 days, but if you happen to vacate in 3, we're just going to go ahead and, waive the charges. And so they just bypassed the law. And so it's the matter of coming up in a way to do it that doesn't just open up loopholes for abuse. But like I said, I agree with you. I do believe there is a distinction there. And if you've got some thoughts on it, I think we'd be open to how that might be workable.
Okay, and Mr. Chair, if I could, a couple more questions from last week.
Try and make them pretty quick because we have another a tight deadline today.
Okay. Under the bill, it says that the local government can't have an ordinance with the effect of banning short-term rentals. What ones of you head up municipality that doesn't like the idea of having them and says, well, we're just going to allow one? I mean, is there something to prevent them from just saying, oh, well, we're not banning it, we have one?
Yes, I believe the language in there says ban or effectively ban. And that the effectively ban piece is what accounts for that because this sort of thing comes up in court in other cases. And saying, oh, we're only going to allow one, or for instance, what some municipalities have done where they've said, oh, we're zoning for this, but we're putting it in the old industrial park where there's literally no houses. That's an effective ban, and so that's prohibited by this as well. What we're really trying to encourage, and the way I think this would be interpreted, is you have to figure out a zoning solution to this. If that is commercial only, if it's an overlay district, if it's geographic, you have to figure out a solution, and that solution cannot be banning or effectively banning.
Okay, and I do have one more. The task of taking on all the inspections of these statewide would fall on Laura. Are we planning on hiring more employees, or is this work that's going to be thrown on the backs of employees that are already sometimes overworked, or how are we going to handle all that?
The inspections will still happen locally the same way they're happening now. We're not going to have the state agency become a enforcement and inspection agency because, to your point, we'd probably have to hire hundreds of employees and balloon an agency that really doesn't need ballooning. So the intent is for the municipalities to enforce inspections, and most of them are already doing that. I mean, they're already inspecting their rentals, so it's hopefully not going to increase any burden on the state.
But it sounds like it could at the local level.
I suppose potentially. I'm not really aware of any municipalities off the top of my head that aren't inspecting rentals that they're licensing. That's usually part of the licensing process. But part of having the excise tax in is to help pay for that sort of inspection and that sort of thing. That right now a lot of municipalities are actually running at a loss.
Okay, thank you.
Yeah.
Thank you, Mr. Chair.
Next question is from myself. One question that has come to my mind is regarding the 6% excise tax.
Yeah.
And we've had other pieces of legislation that have come before this committee that is enabling legislation. And I think that in some of the commentary that we've heard in testimony is that locals do see this as an opportunity to recoup some of the costs that are associated with inspection, enforcement, and the like. My question, though, would be if there is a community that exists in Michigan that says we actually don't need this additional 6%. We feel like our STRs are being managed properly. Is it better to have this be an enabling legislation as opposed to mandated?
I suppose it's possible. We did have discussions early on around whether to make this an opt-in or not. And I mean, I think where a lot of us landed is a community really going to turn down 6%? And also, some of the communities that might turn down 6% are probably also ones that don't really have a lot of short-term rentals in them to begin with. So it's sort of, it kind of seemed like a distinction without a difference. But I don't know that there would be an issue with making it an opt-in. I can't see why that would be a problem, I guess.
And then one just point of feedback is I had a question about the 14 days.
Yeah.
And I think that for an operator, the layman who isn't a lawyer and maybe reviewing this and seeing about entering, I wonder about maybe making the distinction of night's stay to maybe match up with how their bookings occur, whether that be 13 nights stay or 14 nights stay. I just think that would be potentially more clear for the operator and potentially those enforcing this as well.
We basically just duplicated the IRS language, but I think we could make a clarifying statement like that in legislation. I don't see why that would be a problem.
Just a point of feedback.
Yeah.
Vice Chair Burns.
Thank you, Chair. Rep. Andrews, I know that at some point during the testimony today, there was a question about constitutionality.
Mm-hmm.
Can you just speak to that and elaborate on that for us?
Yeah. So this is kind of like one of these red herring issues that's come up in other states that have done this. And essentially, the platforms always make the case that they have some sort of duty to protect this information and not submit it. I will note that we have registry platforms for like Uber and Lyft where information like this gets submitted. Also, in talking with some of the platforms in other states that have done this work in other states, Granicus being one of them, they've told us that often what will happen is the platforms will come up and say, well, we're going to file suit because we don't think we should have to give you this information. And typically what happens is the state says, you know what, forget it. The platform, this information is basically publicly available, which is why this is silly. But the platform can find this information to begin with. But it's basically a legal case that's made to try to grind the process to a halt, and it's part of the platform's business model. But it's really kind of a specious argument, to be honest.
Thank you very much. I have two questions left, and those are probably going to be our two final for today's committee session to allow time to get back to the House floor. Representative Preston.
Thank you, Chair. Thanks for your testimony today. I don't understand the need for the mandated statewide aspect of it. You're kind of sandwiching on some of the earlier comments. Obviously, the testimony provided before shows that local jurisdictions have the power to regulate and mitigate a lot of the issues that are going on. So what remains at the end of this is the tax parity question. And when reading through this, it's not about tax parity. At the end of the day, you're talking about a central registry that I think that they should be able to either opt in or opt out of. I think that's possibly a sweet spot. But the taxation question is going to push them way beyond parity and into a realm of punitive effect, effectively making, short-term rentals prohibitive. And we're talking about, homeowners' rights, property rights to their own property, to do with their own property. We've been pushing for so long on Pure Michigan and Come Enjoy Michigan, and we've been beating that hammer. Now I find myself looking at a situation where we're pulling the funding from Pure Michigan, and do we want people coming to Michigan? I mean, we've created this so that people come to the state and enjoy the state, and we've created this microeconomy, macroeconomy throughout the states that's thriving. And this, once again, this need to move it into a one-size-fits-all for the entire state, I think is just antithetical to what I think could be some good aspects of this legislation being put into place. But it's just, with all the bills, all the amendments, is just a reach too far.
So I appreciate the concern you're expressing here, and I want to say I represent a lot of communities that benefit directly from tourism. Saugatuck, South Haven, New Buffalo, St. Joe. I mean, tourism is a big part of our economy. So I support Pure Michigan. I believe it needs to be funded well. I mean, it's, they found us for what it's worth. We get the tourists every year, but I think it's a very important part of our economy. And our intent here isn't to drive short-term rentals out of the state. If we wanted to do that, we would do something like what New York City did, where they basically killed the whole industry, which I think they're finding was the wrong approach, actually. So what we're trying to do is level the playing field, and the statewide registry it's not really a one-size-fits-all. So the statewide registry is really very easy to create. Because all of this is happening online, by and large, it's really easy for the database to pull this information together. And we're still letting all the local governments enforce this in their own way. The bill's very specific about allowing for municipalities to set their own zoning, their own licensing numbers. So really what we're trying to do is encourage local governments to find the right fit for them. But what we want to do is we want to take the burden off of them in regulating, which is where the crux of this issue is right now. I'll use South Haven as an example, and this is an example that many other communities in the state are dealing with. So South Haven created a minimum or a maximum number of licenses that they were going to permit, and they have an inspection process that they go through. But because our Constitution forbids the local municipality from levying a tax, they have to operate their licensing and regulatory system at an intentional loss. So every year, the taxpayers, the permanent residents of the city, are backfilling the cost on the regulations around the short-term rental industry, which benefits tourists and businesses as well, which is important. But the residents are basically backfilling this industry. And then on top of that, as you heard from some of the local government folks, the extra burden on public safety and infrastructure is enormous. We've had issues in some of our communities where there's been a pool set on fire, gasoline poured into a pool, bachelor party set on fire, and you had fire safety services standing around a gas fire for a whole evening. And that, that's a huge tax on local resources, but the short-term rental owner there doesn't pay for those resources. The tourists don't pay for those resources. And so that's what we're really trying to do here. And so I know it seems like it's out of parity percent for percent with the hotels, but as I stated in my initial testimony, the hotels are planned for when they get there. And so a lot of that burden is built in when the hotel is built. And so this the extra excise tax we're looking at here is helping to level off the playing field for the municipalities. And I'll note, this is not beyond what other states charge for total tax burden on tourism. You see it in Colorado and Utah, Illinois, and it's not driving tourism out of those states. And it's leveling the playing field.
Thank you very much, Representative. Final question, Representative Breen.
I have many questions, but I will stick with one.
Thank you.
First, I want to say this is an improvement from last term, in my opinion. I still have PTSD. I would like to later, we can take this part offline, understand the application of the taxes. I fear that there's an uneven application between all the various different bills and the multiple acts that this is going to impact, as well as I have questions about insurance policies. Is this going to be in addition to, on top of homeowners? What type of a burden are we putting on the owners? But mostly what I'm wondering is, what is the reasonable standard? If we have a municipality that already has an ordinance in place or something in place already, before we upend what is already there, what is the definition of a reasonable application here?
Do you mean reasonable in terms of like what is being done, or reasonable in terms of what we think like the use case for this legislation is?
Well, right now, what I'm seeing is you cannot ban them or do what amounts to an effective ban. What is the standard in which we are applying here? I know you already gave one example,
Yeah.
but can you clarify or further define what would be a reasonable local ordinance under this proposed bill?
Yeah, so I think that looks like a lot of different things, and that's why we really wanted this to be local control focused, because this issue manifests itself very differently in different communities. So like East Lansing, for instance, has set up a special kind of zoning to take care of short-term rentals, and it works for them because their experience of short-term rentals is derived from college sports, right? Same with Ann Arbor, where South Haven, New Buffalo, et cetera, their ordinances are because of this influx of summer tourism that comes in. And so you end up seeing this being applied differently depending on different communities. Grand Rapids has a totally different approach to this that is probably one of the more restrictive approaches in the state. And so it's hard to say that there's a best use case. And the goal here was to say, you know, you can't ban them. You know, our laws are pretty clear. Our zoning is pretty clear on that. But we're trying to encourage, and by stating all of these different tools within the legislation, we're trying to encourage each municipality to find the right fit for them. And then what we're doing here is we're basically building a frame around that to supply them with the extra enforcement support via the database and the excise tax to fund enforcement and infrastructure and that sort of thing. And so that's, I think, the way to think about this, right, is we're saying local government, you figure out what's right for you. Here's your support structure.
Okay, thank you.
All right, thank you. That is going to bring us to the end of testimony and questions here today. I do have a couple of cards to read in. Not wishing to speak in support of the bill, Ron Lemkool, Supervisor of Long Lake Township. Not wishing to speak in support of the bill, Lucy Welch from Spring Lake Township. And I do have written testimony that has been provided to the committee. Some has been outlined already, but I do have written testimony that will be distributed from Mary Sheffield, Detroit City Council President. So with that, I need a motion to... We don't need a motion, excuse me. Seeing no further business before the committee will stand adjourned.